I find introductions kind of interesting, just simply because, you know, we kind of make people sound better than they are. And we all know that we're the same. We're all connected, at least if you allow me to speak metaphysically, I think we're all deeply connected. And I think that we're actually all here for a reason. We're not here by accident, but we're here to do something. And I actually think we all have a responsibility to the next generation. It's something that troubles me quite a bit because, you know, we're actually in charge. Like the group here, our generation, we're in charge right now. We're running the country. And the country we received from the generations before us, I mean, I know that, you know, some awful things have happened in our past, and I know that there's things not to be proud of, but we really received a country that we, you know, had a lot of potential. We had these common law traditions with very strong rights, you know, vis-a-vis the government. The generation just before us had, you know, put many of those rights in our Constitution in the form of the Charter of Rights and Freedoms. We had a parliamentary system where, you know, power was vested in Parliament. You know, regardless of what you think with that, we had a lot to work with. And I am really, really grieved about the Canada that we're going to hand over to my kids, because I already don't recognize it. If you had told me 10 years ago that we would have been losing rights and freedoms, that we would be kind of micromanaged to the degree that we have now, I wouldn't have believed it. Like, I would not have believed it. And the interesting thing is, you know, like, if you study history, it really is kind of a tug of war between governments and people. Like, governments will take power from the people and people will rebel and get it back. But usually it involves force or the show of force. I mean, I expect a police state there to be jackboots and guns and stuff like that. I mean, I really do. And what's happened that I've experienced and you've experienced as there's been this transfer of power, there's been no show of force. Rather, the people demand that the government takes our freedoms away. Because we are generated, fear is generated in the mass media, and something bad has happened, and we demand that our freedoms be taken away. And then people who, you know, kind of like me, that try to tell people, hey, well, are you woken up? Are you paying attention? We get criticized. Lately, I've been getting criticized. People are saying, well, you have been saying that we're going to lose 2/3 of our products, you know, it would number in the tens of thousands. You know, well, health food stores are still full. What's going on? Were you wrong? I mean, I'm just telling you some of the criticisms I've been receiving. And that's kind of interesting. I mean, was I wrong? Where are we? I kind of want to talk about that a little bit. And for those of you who aren't familiar with kind of what's happened in our regulatory regime, prior to 2004, natural health products were unregulated. They were basically all illegal, and yet the industry was growing. Now, in 2004, or before 2004, when you walked into a health food store, did you feel the products were dangerous? No. No. I mean, even now when you walk into health food stores, there's still a number of products that would be technically illegal. But anyway, in 2004, we came out with these new regulations that are quite onerous. And we've been losing products because of them. And I think it's important to just take a step back and go, well, why did we get new regulations anyway? What were we doing? And you'd actually be surprised that, you know, for those of you that weren't involved in that fight, we actually got the new regulations because Health Canada was attacking natural health products under the old regulations. Canadians rebelled and actually forced the government to back down because we wanted increased access. So there was a citizen rebellion in the mid-90s. We wanted increased access. And then Health Canada was tasked with drafting new regulations. And when you sit down and you're going to draft regulations, you kind of have to make some assumptions. And Health Canada was faced with a choice. Well, we could assume that natural health products are dangerous and then draft regulations based on that assumption, or we could assume natural health products are safe. And, you know, just for example, on the safety thing, in the United States, they had a citizens' rebellion just like ours, and they drafted legislation, and they decided to presume that natural products are safe. It's actually in their DSHEA legislation, by law, natural health products in the United States are deemed to be safe. And their regulatory body, the FDA, actually can't take a natural product off of the market by law unless they have evidence that the product is harmful. Now, when you deem something safe, when you restrict the regulatory body's ability to take it off the market, you know what happens? It flourishes. So in the United States, I mean, there's just a whole list of products you can't get here. In fact, who's like me? Whenever I go to the United States, I make a list of what I can't get here. And I already see the heads nodding. And products are a lot cheaper there. Now that's, I mean, it's just common sense. Now Canada, Health Canada decided to take the opposite assumption. So instead of following the US, which was ahead of us, Health Canada said, well, no, let's assume that natural health products are dangerous. And, well, with that assumption, let's draft regulations to protect Canadians from the danger of natural health products. So when our regulations came into force, basically the entire industry was illegal. So the presumption is they're dangerous. The default is that they're illegal. You can't just create a product and put it on the market. That would be illegal. You actually have to go to Health Canada and get their pre-approval in the form of a license. And obviously, when you create a regime like that, there will be a bunch of products that can't get through. It restricts our access, and that's been happening. We've really been losing products, even though the store shelves seem full. And the store shelves do seem full. Like just for example, the store that I regularly shop at, they organize their supplements by type. It's not by brand. So let's say you wanted vitamin D. You can go and they've got like a whole shelf of vitamin D. And literally, you could spend about half an hour looking at all the different types of vitamin D that are for sale in my local health food store. Now, they're all very similar because Health Canada, under these new regulations, has restricted the dose amount of vitamin D to 1,000 international units. And for those of you in the know, that's like woefully inadequate. Like I take 30,000 minimum a day. Okay? Oh, well, don't seem shocked. Look into it. Well, I'm just saying that's what I do. I'm not here to give you advice. But somebody who doesn't know and buys a bottle of vitamin D and follows the label, I mean, you might as well not be buying it. But I'm not here to lecture about vitamin D. I'm here to just basically talk about, you know, where are we in our regulatory regime. And so the shelves seem full, but we are losing products, and products are being dumbed down, like vitamin D, where you can't by law sell like a 5,000 IU capsule or a 10,000 IU capsule. We have to get those things from the United States. So Health Canada makes this assumption that products are dangerous. Is that assumption true? Isn't that a fair question to ask? I mean, if we're going to regulate based on this assumption that they're dangerous, let's ask if that assumption is true. Now, when you are trying to figure out if something is risky, you always have to compare it to other risks. And one of my favorite examples is bottled water. Did you know that some of us die every year from bottled water? So I remember I was driving in my car, I forget where, and I'm listening to CBC radio, and there's a doctor on there who's talking about how long-distance runners in Canada have it in their mind, they have to stay hydrated. So when they're long-distance running, they're always drinking bottled water, and some of them are actually dying because their bodies are under stress, they put out their chemical balance, and they die. And the doctor was frustrated because he says, you know, you really can't die from dehydration if you're a runner. Your body just forces you to stop. And the purpose of him being on the air was to try and educate Canadians, don't overdo it when you're with the water. And but now, can anyone tell me how many Canadians have died this year from natural health products? You would have seen it in the news because none. Okay, yeah. So you wouldn't have seen it in the news because there haven't been any. Actually, we could say that for all of Canadian history. So I'm not aware of a single death in all of our history caused by natural health product. And in fact, I did an access to information request to the federal government, and I said, well, let's just go back to 1867 when we became a country. Can you show me, Health Canada, any information to indicate that a Canadian's ever been killed by a natural health product. Now, we couldn't go back that far because we just didn't keep the records, and if we did, there's no way for them to know. But what they were able to do is say, hey, but we did start in 1965 keeping records for adverse drug reactions, and so we can certainly tell you from 1965, and they couldn't point to a single one. And, you know, I've been challenging them in lectures for years, like, you know, show me the body, so to speak. So I'm fairly confident in saying we're not aware of a single death. And so isn't it interesting that technically bottled water causes causes way more deaths? Like, statistically speaking, it's more dangerous. So those of you who've heard me lecture, you know, I use peanut butter and shellfish as examples too, because they kill people every year, right? So, statistically speaking, they are way more dangerous. It's about 13 years ago now, a client of mine hired Professor Ron Law, who is a risk expert in New Zealand, to use Canadian government figures and come up with the relative risk of natural health products versus other dangers. And he actually, well, he couldn't find a death from a natural health product, so his comparison is, you know, the risk of serious harm from a natural health product. And in fact, we have a table at our booth 209 if you want to get a copy. It's really entertaining. But did you know you are over 17 times more likely as a Canadian to be struck by lightning than to be harmed by a natural health product? Now, obviously, if you're struck by lightning, you're not going to survive. So, you know, I kind of wonder, how much has this natural health product directorate cost us as Canadians? Like, it's been running for, I think, 12, 13 years. They created an entire different directorate of Health Canada. I mean, there's a large number of employees. They got their own building. Like, is it $100 million a year? Is it more? Like, are we in, I don't know, I'm just pulling figures out of the air, but, you know, literally have we spent like over $1 billion on this directorate? Likely. And then when you figure the amount that these new regulations have forced the industry to spend, we'll be in the billions of dollars. Now, as taxpayers, if we got together and we said, listen, why don't we create a separate lightning directorate in Health Canada? And you're laughing, but hear me through, because we could pass regulations forcing lightning poles to be erected in all open public areas like soccer fields and playgrounds. We could have big posters, you know, educating, you know, the kids what types of clouds to avoid and stuff like that. We could, you know, get on the radio different risk, you know, things. And as funny as that sounds, because it sounds funny because we wouldn't be willing as taxpayers to pay for it. Because even though there's a risk, even though we would actually save a few lives, we wouldn't put up with it. Why are we putting up with paying for a natural health product directorate when we're not going to save any lives? It's interesting, back in 2003, I was called to testify as an expert witness in front of the Standing Committee of Health because there was a bill, Bill C-420, working its way through Parliament, and that bill was going to move natural health products into the food category. And if that had happened, then our new regulations would have been meaningless. And so the real issue before the committee was, well, should we let these new regulations come into force or should we not? And I asked the Standing Committee of Health, I told them, listen, there hasn't been a single death in Canadian history caused by a natural product. And you know these regulations are going to take natural health products away. If you let this happen, if you let the regulations come into force and we come back here in 10 years, will the regulations have saved a single Canadian life? Well, obviously the answer is no, right? If there's never been a death in all of our history and you restrict the number of products, there's not going to be a death. But then I asked a question, and some people got really angry over this question, and the media really doesn't like it when I ask this question. But I asked the committee, I said, okay, let's say you let these regulations come into force. We all know they're going to restrict access to products because that's what they're designed to do. And we come back here in 10 years. How many lives will the natural health product regulations have cost? Isn't that an interesting question? You can see why they don't like that. But, you know, when you're regulating in the area of public health, shouldn't you ask the question, just wait, are we going to cause deaths? I mean, if we're doing it for our safety, shouldn't we ask that question? And I firmly believe we actually have caused deaths, it will be devilishly hard to quantify, and I'll explain why. And let me use natokinase as an example. Does everyone here know what natokinase is? Oh, not many. Okay. Some do. Natokinase is really just an enzyme that is derived by a soy food called natto. And natokinase has many uses, but where it really shines is it is a natural blood thinner that is amazingly safe. It's amazingly safe. In fact, anyone can go into Health Canada's adverse reaction database and search for different things. Has there been any reports filed? And just a word to the wise, if you're going to do that, do every brand name that the drug is sold under plus its chemical name to try and get. But I did that for natokinase. I couldn't find any adverse reactions in Canada. But Health Canada in November of 2012, so just a little over a year ago, under a new regulation said, natokinase is way too dangerous. We're not going to allow Canadians to have natokinase. It caused a bit of a fluff, actually, amongst medical doctors, because, I expected, naturopathic doctors and homeopathic doctors and that to be managing their patients that needed a blood thinner with natokinase, because they can't prescribe the chemical ones, and they wouldn't want to anyway. And but a large number of medical doctors. So those of you familiar with Dr. Rona, for example, he wrote extensively complaining, like, this is a problem, because medical doctors also were not liking the chemical blood thinners. And it's kind of funny, at the exact time Health Canada was taking natokinase away, emergency room physicians were making the news because they were complaining about the deaths being caused by a new blood thinner called Pradaxa. In fact, let me just give you a friend sent me a news article at the time. Yeah, it's November 3rd, New York Times, if anyone wants to dig it out. And the story is called A Promising Drug with a Flaw. And what was happening is people who were on Pradaxa, if they ended up taking too much, they're actually bleeding out. Their blood's too thin. So that you go to the emergency ward, but the doctors couldn't do anything to stop the bleeding. They just basically watch you bleed to death. And they were frustrated because with the other blood thinners, like rat poison, warfarin, if you show up at the hospital and you're bleeding out, they give you an injection of vitamin K and it stops it, right? But vitamin K doesn't work for Pradaxa. So there was nothing they could do. And the article reports that in the United States in 2011, there were 524 deaths that were recorded caused by Pradaxa bleeds outs. And I thought, whenever I read an American figure, I figure, okay, their population is 10 times our population, so if they had 524 deaths, we have Pradaxa here, so, roughly 52 deaths in Canada, all things being equal, right? And you can go and search the adverse drug reaction database for Pradaxa. I haven't added up all the numbers, but it will shock you. It will shock you what you will find. So, what happens to the group of Canadians who are on natokinase, perfectly safe, being safely managed, when natokinase is taken away? They have to transition to some other blood thinner. I'm not aware of another natural one. So, the naturopathic doctor, they may be out there, but I really have not had any doctor or naturopathic doctor say, I can safely transition them to something else. Most of these people were sent to medical doctors, or the medical doctors had to put them on a prescription pharmaceutical blood thinner. And so the point I'm trying to make when I'm saying, well, have we lost lives? What do you do when this group is transitioned to the chemical pharmaceutical blood thinners? We know that a certain percentage are going to have adverse reactions, including deaths. It's a statistical fact. And natokinase is gone. So my point is, and I just picked one example, is can we pretend that you can take a product that people are being safely managed on a serious condition, transition them into a group of products that is a much higher risk profile, and pretend that there's no health consequences? Now, but as far as quantifying, if somebody shows up who was in this natokinase group and they show up at the hospital and they die under a chemical pharmaceutical blood thinner, if a doctor files an ADR report, an adverse drug reaction report, they're not going to say, well, they died because of the natural health product regulations. They're going to say, well, they died because of an adverse reaction to whatever the drug was, not because they were safely managed and some other drug. Health Canada took it away, and here's... So you see, that's how it's hard to quantify, right? So, but I could go through, except there's so much stuff I want to cover today. I could go through a whole bunch of, individual cases where people have called me and said, I've lost this product, what the heck do I do? And I'm aware of at least one person that's no longer with us because they couldn't get a product. The point I'm making is, when you take away products that people are safely using for serious conditions and force them into a more risky category, there are health consequences. This is not small stuff. This is serious. And these questions need to be asked. I believe we're causing deaths. But people are complacent because when you walk into the health food store, my gosh, the shelves are full. I mean, really, the shelves are full. But if you're in this group of people that relied on a product that's missing, and there are a lot of products that are missing, if you are a person that depended on a product that's been dumbed down, you're in trouble. And when I say dumbed down, it's like the vitamin D. You used to be able to buy 5,000, 10,000 IU vitamin D capsules. You can't anymore because they're illegal. There's a lot of products where, especially the multi-ingredient ones, where the manufacturers have had to reduce the amount, the therapeutic amounts, where they basically become ineffective. I was giving a lecture in Aurora, and one of the persons in the audience was a manufacturer of professional products, not for the public. It would go to naturopathic doctors, stuff like that. And he interrupted me and he said, we had this product, I forget which one now he was talking about, and he said, Health Canada kept getting back to us saying, well, we'd have to drop this ingredient, we'd have to drop this, like the amounts. And he said, finally we sat down and we said, well, we're pretty sure this product won't work. Like, we can get a license, but we're pretty sure it won't work, so we just decided we're not going to make it anymore because we don't want to defraud the public. But not every manufacturer's taken that position. Some of them hope that they're, the healthcare practitioners will say, well, ignore the label and take, 5 times as much, or, supplement with this other one. But if you don't know, a lot more people are going to be buying products off the shelf, following the direction, and they're not going to get the relief, and then they're going to keep looking for other things, and a large group's going to end up in the pharmaceuticals, and off we go. But it's not rosy there, and it's not rosy for the poor. I mean, the poor already couldn't buy, if you're on welfare or something, you're not buying natural health products because you don't have the disposable income. And when you impose a whole bunch of costs on an industry to make us safe, eventually those costs get passed on to the consumer, and you'll have a slow rise. It's actually been amazingly mitigated. Like, manufacturers have been pretty good because of the amount of competition out there. It's been slow, but it's coming. And Health Canada has assured us that eventually we're going to have what's called cost recovery in the natural health industry. And for those of you who don't remember cost recovery, when Brian Mulroney was our Prime Minister, he brought in cost recovery, and it makes some sense. He said, look, if the government is going to regulate an industry, why should the taxpayers cover the entire cost of that industry? Shouldn't the industry be paying some fees to the government to help cover the cost of the bureaucracy? That's the idea. And so I can tell you, for example, with Health Canada, the fees that the chemical pharmaceutical companies pay for license applications and other services from Health Canada actually keeps Health Canada going. They would have to shrink in size dramatically, but for the fees paid by the chemical pharmaceutical companies. And I had noticed, this is probably about 12 years ago, when I would get internal Health Canada documents during lawsuits, they would be referring to the pharmaceutical companies as their client. Now that's shown up in some public documents, and they don't deny it. They refer to the chemical pharmaceutical companies as their client. Isn't that interesting? The bureaucracy that we depend on to keep us safe. Like, cost recovery is not a bad idea, but I think in the area of like drug approval, no, the taxpayer should bear the whole cost. Like, there shouldn't, the bureaucrats shouldn't think their job depends on these license applications. But the idea is eventually for natural health product companies to be paying for the Natural Health Product Directorate. And it was about 4 years ago now, Health Canada kind of floated a fee schedule, and a lot of companies said we weren't going to survive. Like, Health Canada backed off. It created a lot of pressure. But just my point is that's coming down the pipe. It's kind of a storm cloud that's on the horizon. Another storm cloud is this comprehensive economic trade agreement with the European Union, CETA. Did you guys remember hearing about that in October? It was like front page news and television. The Harper government had struck a comprehensive economic trade agreement with the European Union. We were going to have full employment and be wealthy, and the tulips are going to bloom in January in Canada. I mean, it was just hyped to the max. Does anyone know what it says? This is a trick question because you can't get the text. They're still working on it. It's secret.
Yeah, but why does so many things turn out to be secret?
Well, I mean, isn't that... Just so everyone could hear the question, why are so many things ending up being secret? Like, just wait until I get to talk about Vanessa's law in a second, which is one of my big beefs. I have no idea. To me, government secrecy is not consistent with a liberal democracy.
I think it was invented by Harper.
Well, and please let me lecture. So... Yeah, it's just interesting. The terms are secret of this CETA agreement. But what I'm concerned about, and I don't know because it's secret, is that if it covers natural products so that, we can trade with each other in natural products, I can't see the European Union adopting our regulations. And if we have to adopt their regulations, I can tell you... we're going to look back at today as the good old days because we are going to lose a lot. Their regulations are just so much stricter than ours. And it is a real worry. And then, of course, actually, enforcement of our own regulations are a worry. Even though we've had these, still call them new regulations, they're 10 years old, but it was just so difficult for everyone to try and get through this licensing process that it's actually not finished. It's kind of finished now, but Health Canada said, okay, we should be through it now. We're going to start enforcing, because there's still a lot of products on the market. There's a whole lines of products where, like, the manufacturers actually never tried to get licensed, and there's some where people have tried to get licenses and they can't, but they've kept selling them because there's no enforcement. And people have told me, oh yeah, well, when Health Canada tells me I have to stop, I'll stop, but until then, why, right? So once they start enforcement, which they've told us will be this calendar year, we're going to lose some more products. Another storm cloud, and this one's going to be a little harder for me to explain, is Bill C-17, which was introduced in December. Now, nobody will have heard of Bill C-17, but if I say Vanessa's Law, anyone heard of that? Do I get any nods? Oh, a couple. So, and I need to be gentle here. I'm going to talk about Vanessa's Law, and I'm going to tell you her story first. I don't mean to criticize the story. I don't mean to be insensitive to what really was a tragedy. Because the government has chosen to brand this law as Vanessa's Law to try and create an emotional response in us so that we'll support the law. And so as I understand the story, is that Vanessa was a teenage girl who was prescribed a chemical pharmaceutical drug. She took the drug as prescribed. She had an adverse reaction and she died. Now that is a tragedy, and that's not something we want to happen to anyone. But her story is being used to promote this bill. It's a bill to amend the Food and Drug Act, apparently to make us safer. And just understand, whenever the government chooses to use a story like that, a personal story, that it is meant to garner our support through emotion. Because if we can feel sad, or we find out about a tragedy, it creates fear, and we want to prevent that from happening to anyone else. In fact, fear is the tool that is used for us to demand that the government takes our freedoms away. If you're not going to use force, you use fear. So, but I don't mean to be critical of Vanessa's story, but I do need to talk about this bill critically. My first concern about the bill, and when I tell you my first concern, you're first going to go, well, why is that a concern? Well, and then I'll have to explain it to you. But my first concern about this bill is that the minister, which really just means Health Canada bureaucracy, can order anybody to recall a product or could order anyone to move the product to wherever the minister says to move it. So the minister could rent a warehouse and say, you move your product to our warehouse, basically take your property. And some people say, well, just wait a second, don't you want the minister to be able to order a recall of a dangerous product? Right? Like, isn't that a good question? And, you know, actually my answer is well, if it's according to the rule of law, yeah, I do. But we have to talk about the rule of law for a second. And when I talk about the rule of law, what I mean is just simply this fundamental principle that before the government can take control over your person, so either kill you or imprison you, or before the government can take your property, they have to go through an independent court. So like imagine the government's over there against that wall, and you're over there against that wall, and the government wants to either take control over you or your property. There's a court between the two of you, and the government has to go through the court which supervises what you're doing. Somebody needs some water. So I have no problem with the government accessing you or your property if they're going through a court, if there's supervision, if it's done out in the open, because the secret exercise of power is not consistent with a liberal democracy. Now, so this new law allows the minister to order a recall or basically order you to move your property to where the minister controls it. These orders are secret orders. And what I mean by that is because the exercise of power has to be done in the open in a liberal democracy, we actually have an act called the Statutory Instruments Act, which by law requires that, you know, any orders or exercise of power, you know, by the government, the order has to be filed with a committee, and the committee looks at the order and tries to determine if it's out of line, if it goes too far in encroaching on rights and freedoms. And the order also has to be published in the Canada Gazette. So Parliament can look at it, the media can look at it, the public can look at it. It's an exercise of power out in the open. But these new orders are exempted from the Statutory Instruments Act. So the minister can order a recall, can take control over property, and it's done secretly. Now, you have to know the minister had lots of powers to protect us before. For hundreds of years under the common law, if anyone is violating any statute, the minister can go to court and get an injunction and any other ancillary order the court feels is necessary to protect people. So all the minister would have to do, if in the very rare event that a company wouldn't do a recall, well, pull the license, go to court, get an injunction. Well, you could get a search warrant and seize it if you were really concerned. Oh, but now just wait a second. There's a problem with the injunctions. It's supervised by court. And I forgot, that won't do. It's public and supervised by court. And I did tell you the minister could go and get a search warrant, but dang, then they have to report what they seize to a court, and the court supervises it. Dang, that won't do. They can seize under Section 23 of the Act, but oh no, then they have to start court proceedings. Section 30, Decimal 1 of the Act, the minister can actually make an order. Doesn't have to go to court. Can order anyone to stop selling a product. Oh yeah, but they have to table that in Parliament and it has to be confirmed. Dang, but you get the point. These are just ones that come off the top of my head, that the minister already has the power to protect us from dangerous products. Why is it that we basically have to give bureaucrats the authority secretly to take control over property? See, that's my concern. Whenever we move away from the rule of law, we basically create tyranny. Pull out any dictionary. All tyranny is the unfettered exercise of discretion. It's actually not even meant as a pejorative term. That's all tyranny is. And you see, that's why the rule of law, you can't have tyranny. Because the government can't just get to you. It has to go through a court. It doesn't have unfettered discretion. But all we're doing is we're creating unfettered discretion in the area of health law. And another concern I have is the penalties in this act. If you defy one of these orders, the penalty is a fine of up to $5 million and or 2 years in jail for every day you defy the order. And you see, what's the problem with that? Some people will go right on. Then, if there's a dangerous product, nobody will defy the minister. But the problem is well, what about those cases where the minister gets it wrong? And you should defy their order. I mean, I had a case, True Hope, where the minister said, you stop selling that product and you recall it. And they said no, because if we do that, people are going to die. True Hope makes a product called the Empower Plus to treat bipolar disorder and major depressive disorder. Well, they said no, we won't. And so Health Canada, made a seizure and started doing whatever they can to make the product unavailable. And then they charge True Hope. It goes to court, and the court says, good on you, True Hope. You are guilty as can be. You are selling a product without a license. But I'm going to acquit you because it was necessary, because deaths would have ensued if you had listened to the minister. Deaths ensued because the minister made the product unavailable for a period of time. Like, there were deaths. So the minister got it wrong. In my law practice, when firms call me and say, Health Canada's demanding that I recall a product, we have to ask them a whole bunch of questions. And it's the first questions are, okay, what's the product used for? If it's a serious condition, we have to know, well, are there other products available on the market that people could transition to? And if there aren't, or if Health Canada is also making demands of those manufacturers to remove it, then we actually have to hire a risk analysis person to tell us, is there likely to be harm or death if the company listens to Health Canada? And the reason why we have to do that, usually we hire a medical doctor to do that, is if Health Canada tells my client to recall, but recalling the product will cause serious bodily harm or death, then my client's guilty of criminal negligence. Because in Canada, we don't allow people to put an effective treatment on the market, have people come to rely on it, and then pull it off the market and watch them suffer. If they die, it's criminal negligence causing death. The penalty is life imprisonment. Aside from all the civil consequences, can you imagine being sued by the families? So, to give proper legal advice, we have to know, well, what's the risk? And I can tell you that there's been a couple of occasions where the analysis has come back saying, you better not recall, you're going to cause serious harm. And the client hasn't. But the client's been able to do that because there weren't $5 million a day fines and up to 2 years of jail a day you defied the minister. Now my legal advice would have to change in those situations, saying, too bad, I think living on the street's a good thing after you get out of prison. Like, you're going down. And there's a problem whenever you give the government too big of a hammer. So another interesting thing about this new act, this Vanessa's law, is some privacy concerns. Is that the minister, to try and figure out if there is a serious risk of injury. I don't know what that means, because it's not a risk of serious injury. It's to determine if there's a serious risk of injury. And so, like I say, I don't know what that means. But for the minister to try and figure this out, the minister can basically make a demand of anyone for any information. And the minister doesn't have to think that there's a risk. It can be a pure fishing expedition. And minister really will mean a Health Canada employee. But what jumped out at me is I thought, if Health Canada has their bee in the bonnet about a specific product, they could just basically call every doctor or every natural health practitioner and say, I want all your patient records for anyone taking this product. And there's no safety protections. And I just thought that's very interesting. Another interesting thing about this act is that it allows the minister, this is kind of like a return of Bill C-51, it allows the minister to incorporate by regulation any other document. And it's very clear that as the document might be changed from time to time, that remains part of our law. So the minister, for example, could pass a regulation saying, well, we're adopting these European Union recommendations or regulations. Or we're adopting, this trade association has set safe standards for this list of ingredients, and we're adopting that. And that then becomes Canadian law. Even as these other groups amend their documents, the amended document is automatically our law. And that is a loss of our Parliament's sovereignty. So using the example where, let's say we adopted European Union regulations, and let's say there was some part of that you didn't like. Well, you don't go to Parliament and lobby them to change it, because they have no control over it. What do? Do we go to Brussels? Do you see the problem? you see how that's undermining our parliamentary system? Now, Bill C-17, if you get a copy and you read it, you might say, but Mr. Buckley, I don't think this applies to natural health products. And I have to tell you, I don't think it applies to natural health products either, but I think it could apply to natural health products, and if the government just tweaks a regulation. So I almost think, we've called it at the NHPPA this Trojan bill, under the Trojan horse, and the reason is this. Why I say it doesn't apply to natural health products is like Bill C-51, it creates a new class of products called therapeutic product. And it's clear that therapeutic product includes drugs. And natural health products are normally in the drug category. But it says at the end, but does not include natural health products as defined by the natural health product regulations. It's kind of a funny little thing. And so, on its face, it doesn't apply to natural health products. But what I thought the danger is we'll all read it and go, oh, we're safe. It doesn't apply to us, even though it undermines the rule of law. And there's a whole bunch of stuff there we shouldn't allow in any legislation. But it doesn't apply to us, so let's not get excited like we did with Bill C-51. Let's not stop it. And then it passes. And then all the government has to do is pass when I say pass a regulation, you understand regulations aren't voted on? If the government wants to change a regulation, the government just publishes the change in the Canada Gazette. It waits a period of time to see, what the comments are. It can completely ignore the comments. It can be 100%, you better not do this. Doesn't matter. And then they just publish it again in the Canada Gazette, and it's law. No votes. Vanessa's law could pass, and then all they have to do is pass a regulation changing the definition of the natural health product. Bang. And it applies. That's where the Trojan horse comes in. If it really isn't meant to apply to natural health products, all they have to do is put the definition of natural health product in the bill, add it to the Food and Drug Act, and then at least Parliament would have to vote. So another problem that's arisen that I want to talk about is a couple of court cases. One isn't recent and one is, but it's important because it's undermining our ability to actually address these issues in court. Like some people are really frustrated, we've been lobbying, we've been writing, we've been calling MPs, it just seems to be getting worse and worse, nothing's happening. And we think, well, at least the courts can protect us, right? And now the courts, anyone who's ever actually tried to go to court against anyone, has anyone ever gone to court against the government in this room? Okay. The court process, and I'm a lawyer, I know, it's really expensive. Like, courts are not for the poor. Okay, they're not. So you have to have substantial means or you're not going to be able to afford to go to court. But going to court against the government is really interesting because they make it as drawn out and as expensive as possible, which as a taxpayer should upset you because if we're going to have the rule of law, then we have to be able to settle our disputes with the government in court. Like, think about it. Let's say, you and I, we get into a dispute and we can't go to court because there's no court system. Like, sooner or later, you're going to come and beat me up and then, okay, dispute's over. But we don't want to settle our disputes that way. We don't want to be having duels and fights and stuff like that. I mean, people fight hard to get the rule of law because we want to be able to settle our disputes in a civil way. Well, the same with the government, right? I mean, we didn't like it when the soldiers would just come and take what they wanted and, if the nobleman liked your daughter, the soldiers would come and take her away. Like, no, you want us or you want our property, you have to go through the courts. And the part of that is, well, when we have a dispute with each other, we go to court, right? And let a court. But for that to work, for there to be rule of law, we have to be able to go to court and get relief. And so I want to talk about two cases that basically say we can't do that. In very different contexts. And the one is the True Hope Federal Court thing. And I'll just give you a little more background on True Hope. So I've already told you they have this product to manage bipolar disorder, major depressive disorder. So in 2003, Health Canada was saying, you can't sell that product because you don't have a product license. Now, it's a natural health product. It now has a product license. But back in 2003, we didn't have the new regulations yet. They were just about to come into force. They're already on the books. They're already drafted. They're already gazetted. But they didn't come into force till 2004. Health Canada themselves said there were 50,000 products without a license, but for whatever reason they wanted to single out this one. And the company said, no, we won't stop selling. The product is manufactured in the US and it's shipped into Canada. So the way Health Canada took the product away for a little period of time was they seized a shipment that was coming into Canada. It was a shipment that was to go to 23 different individuals, so it's already packaged and labeled for 23 different people. But to get through customs easily, they would consolidate shipments. So they seized that shipment, and then they start telling customs to turn all the other shipments away. And True Hope was so alarmed, thinking people were in danger, and we know people were in danger, that they started a federal court proceeding to try and get Health Canada's actions to be declared unconstitutional. And they started what was called a judicial review. I want you to understand, in a judicial review, you can't even ask for financial compensation. Okay? True Hope wasn't after any funds, anything like that. They started a process where you couldn't even ask for compensation. They were just asking for a declaration. And what True Hope was saying is listen, before you seize anyone's vital medication, two things have to happen. And we're only talking vital medication. But if you're going to seize somebody's vital medication, surely to goodness, you have to tell the people you've seized their medication. Because Health Canada didn't tell anyone. Could you imagine you're waiting for vital medication to come in the mail? Health Canada has seized it and they don't tell you? Like, how are you going to make plans to, get either a different medication or the medication that your first choice or whatever? So we were saying, no. Surely under our Charter of Rights and Freedoms, if you seize somebody's vital medication, you better tell them. And then the next thing we said that should be a constitutional requirement is there has to be some accessible way for then people to argue with the government that their need for the medication outweighs the state's need. There has to be some balancing, shouldn't there? I mean, here we had a case where True Hope's only crime was not having a license, where the whole industry was illegal, didn't have licenses, because you couldn't get a license. In a couple of months, new regulations were going to come into force. Like, what was the government's interest, really? And yet, people's lives depended on this. In fact, I led evidence that Health Canada's actions caused death. And one of the witnesses was Ron Lajeunesse. He used to actually run all of Alberta's mental health programs. But at the relevant time, he was the president of the Alberta branch of the Mental Health Association. He actually held press conferences blaming Health Canada for suicides. And his evidence was, he actually ended up going to one of the funerals of Canadian mental health associations members who committed suicide when they ran out. We had evidence from Dr. Charles Popper of Harvard University, who is a leading world expert in bipolar disorder, was just unequivocal. You take a product like this away, people are going to die. There was a whole bunch of evidence. Health Canada, there were so many people phoning Health Canada when they were restricting access to this product. We know from their internal emails they were just getting upset. So they created what they called this 1-800 crisis line. It sounded great to the public. They do this announcement. We know people are concerned, so we created this 1-800 crisis line, and you can call and speak to, professional counselors. But internally, we know that the only reason is they didn't want to take your call. So if you phoned the Minister's Office or Health Canada, as soon as you said True Hope or Empower Plus, they would hit a button, and you would be involuntarily transferred to this crisis line. But what they didn't account for was these people would take notes. And there were literally almost 800 pages of government notes of people begging for their lives, right down to people saying, and they got names, addresses, times of call, and people would say things like, what are you going to do when I commit suicide? It's spooky to read this stuff. But anyway, just to keep going, so I lead all this evidence, and I'm asking the court, I'm saying, I want you to find as a fact that Health Canada caused deaths. And then you're going to find, court, well, this violates our charter rights, and you're going to say, yeah, when you seize vital medication, you've got to tell people, and you've got to give them a right to be heard, so there can be some balancing between their need and the state's need. Well, what the court did was the court said, Mr. Buckley, your clients do not have standing to put that evidence in front of me. Standing is a legal term. literally means you have the right to stand before the court. Now, my clients were True Hope, the shipper, and one of the 23 who was the receiver who was purchasing it for 2 of his kids that had serious mental illness and depended on the product for their lives. Now, you're telling me the shipper and the receiver, my clients, don't have the right to stand in front of you and say the property you seized, the law under which this was seized was unconstitutional? And the court said, no, you don't have standing. All of the evidence was excluded. There's no evidence. You know, it's like the court moves all the evidence behind them and is looking this way, blue sky, birds singing. I don't see a charter violation. Case dismissed. And then the government went after us for our legal costs. Icing on the cake, eh? So, yeah, which was really hard for the client to take. You know, you're going to court to seek a declaration. There's no fiscal advantage for you. You're just trying to make sure Health Canada doesn't kill anyone else again, and you have to pay their legal costs. It was just a thing of beauty, I can tell you. I can't even say that. It upsets me. So the next case is a much more recent case, North Regent RX. Anyone familiar with their case? So they had a product, I think yesterday I called it Libidor, and I was corrected. Apparently it was Libidex or Libidas. It doesn't matter if I've got the product name right, but it was basically a herbal Viagra. And it was super popular because it was effective. And the Health Canada comes to Regent RX and said, well, our lab has analyzed your product and we have found sildenafil. Now, sildenafil is just the chemical active ingredients of Viagra. So basically, Health Canada was saying, your product spiked with Viagra, you better recall it. And they dutifully recalled it. And then they had independent labs look at their product, and the independent labs couldn't find sildenafil. And so as I understand it, according to Regent RX, is basically the Health Canada lab was incompetent and negligent and absolutely wrong. But it destroyed their business. I mean, that was and understand in destroying their business that this is another example where there would be a health consequence. Because if you've got, and this was a widely used product, if you've got a product widely being used for erectile dysfunction that's safe, and you take that away, a certain percentage of those people are going to move over to Viagra and Cialis, which has a very high risk profile, and eventually some of them are going to have adverse reactions. But in any event, North Regent RX goes to court and sues the government for damages, saying, hey, you were wrong, you were negligent, you've destroyed our business, we want damages. And the court said, go away. Health Canada does not owe you, a manufacturer of a natural health product, any duty of care. And I thought, wow, isn't that interesting? So people whose products are seized can't go to court. Manufacturers whose businesses are destroyed can't go to court. Do we have the rule of law? Like, how are we supposed to settle our differences with Health Canada and the Government of Canada in the area of health when we, for those very few who could afford court proceedings in the first place, we can't get there? Do you see the problem? And so we are kind of entering this phase where, we're losing these freedoms, we're losing these products, and we're also losing the rule of law in the area of trying to solve it. And I was thinking, the North Regent RX thing really got me thinking that we have to push doubly hard to get that Charter of Health Freedom through. I don't know, anyone here aware of the Charter of Health Freedom? I'll be so disappointed if some people are. Google Charter of Health Freedom and read the document. Groups from across Canada got together and just asked the question, how do we solve this problem? And we determined we needed basically almost like a patient's Bill of Rights, like a piece of legislation that would enshrine our health rights, including our rights to make fundamental decisions affecting our bodies, all things that the courts say that we have. There's nothing new in there. It's just but codifies it. And, but it also prevents the government from removing things from the market, such as nattokinase, if the risk of removing it from the market would be greater than the risk of leaving it on the market. See, if we're actually concerned about health, you always have to have a balanced risk analysis. And it creates a health freedom ombudsman to shame the government when things like the True Hope thing are happening. Because the government doesn't listen to us. The courts aren't listening to us. We have to have some mechanism. So I would really appreciate it if all of you would Google Charter of Health Freedom. We had sent the charter to every MP, and well, actually, we had NHPPA supporters do that. And the government got back to us with, their regular form letters. Oh, we have this objection, that. It's, basically explaining why different bits of the charter were a problem. So we have a response package that we'd actually like people like you to pick up at booth 209. I think we still have time after the show. I'm going to be done in about 2 minutes. We've got a package. It basically tells you what happens and tells you what to do, and we'd actually appreciate if you would create some pressure on that. But we need to push to try and get the charter through. I can't think of anything else that would be of assistance. So please educate yourself with the charter, and please be active, because we do have a responsibility to be making a difference. And right now, the Canada we're passing on to my kids and your kids and the next generation is not one we want to pass on. But it's not too late for us to make a difference. I mean, I think we're all aware that people are starting to wake up, not just in this area, but in other areas. And all of a sudden, there's just kind of a crystallization and things change. So they will change, providing we keep pushing and putting our energy in that direction. So I just ask you to be really mindful of that. It's not a lot of work to write a letter to the MP or phone or have a meeting, and to keep yourself educated and involved. And I'd also ask, at the NHPPA booth, if you're not on our mailing list, we have a sheet where you can give us your name and your email address, because when we do need some action, you need to be plugged into a group like this so that we could at least say, hey, there's this problem, we need this action. Like, so for example, a couple of years ago when the Consumer Product Safety Act was working its way through Parliament for the second time, we put out an alert because the Senate was not, it got through the House of Commons, and the only chance of stopping it was in the Senate, and the Senate wasn't going to call any witnesses against the bill. So we put out an alert. The Senate was flooded with demands to call people like myself as witnesses. The Senate did. They amended the bill. And so Harper had to prorogue Parliament and try again. You see, so we can make a difference. You can make a difference. But if you're not plugged in, you can't participate. So I need you to just start thinking, first of all, this isn't this onerous. It's actually kind of exciting to be involved. And we just need to be involved and we'll make a difference.